Good afternoon, everybody. Welcome to the Year in Review in Collective Bargaining. My name's Ian Campbell, and before I introduce the rest of our panel, we're just going to take care of some administrative house cleaning to make sure everybody knows where everything is and if they need help, where to go. To turn on the closed captioning, you just click on the CC button under the video window. If you need to download materials, just click on the materials link. If you have questions throughout the presentation, we're going to leave some time at the end to deal with them, so we kindly ask that you type them into the question tab, and we will try and get to as many of them as we can towards the end. And the tech support button, if you need any help, just please click on the button at the bottom of the screen there, and somebody will help you out. But most importantly, we wanted to draw your attention to the survey option. We really do value your feedback, and so if you think we're great, if you think we're horrible, whatever the case may be, we'd love to hear from you. And so please do click on the survey link and provide us with your feedback at the end of the session. So with the administrative housekeeping now taken care of, we can dive right in. Let me start off by introducing the panelists. So we have Dave McDonald. Dave practices out of our Vancouver office. Among many talents, he is actively collective bargaining in many different industries. And I can say the same thing about Karine Fournier, who is joining us from our Montreal office. And she is actively at the very moment dealing with several very contentious negotiations. I'm Ian Campbell, and I'm based out of the Toronto office. And why you have three of us on the panel is we're all out there in the trenches, collective bargaining, like many of you are. And so we're hopeful that we can bring a national perspective, enlighten you as to some of the trends that we're seeing, try and explain some of the phenomena and why it's happening, and also just give you a little bit of local flavor for not only what's happening broadly, but what's happening in the different parts of the country that may differ slightly. So with that, perhaps we'll get started and start just talking about some of those trends. So what are we seeing out there? Well, I think we're seeing we are seeing the most challenging bargaining environment from an employer perspective in over 30 years. I think there's a number of reasons why that's so. We gotten really used to the good days, low inflation, low interest rates, wage increases that were suppressed as a result. Until about 5 to 10 years ago, we had many governments that were more than willing to intervene and assist where disputes couldn't be, where negotiated settlements couldn't be reached by way of interest arbitration and back to work legislation. All of that has sort of fallen aside. And so we're sort of now in a brave new world. And the brave new world is one where interest rates have now been higher for a couple of years. We're dealing with inflation, and though it's softened slightly, the impact of it has really started to hit home in the last 12 months. And so everybody's cost of living is going up. And that's something we all experience, whether we're buying gas at the gas station, whether going to the grocery store. It just costs more to make by, let alone to try and renew a mortgage or to pay rent on your apartment. And so it's costing more to live. And naturally, when it comes time for employees to want to renegotiate the terms and conditions of employment, they're expecting an increase that will assist them in offsetting the increased costs they're seeing. And when costs are going up at only a couple percent a year, well, that's something that most employers can manage without significantly upsetting the apple cart. But when we're in a world where those numbers are significantly higher than that, and employees aren't just looking to make up inflation, they're looking to go a little bit beyond, it can become quite the struggle. So we're going to talk a little bit about the wage dynamics and get into some more details there in a moment. But other factors that are impacting the analysis are that in many sectors right now, we're dealing with a really tight labor market, especially for skilled trades and certain other positions where you're in competition. People that used to pay minimum wage or just slightly above are now having to pay well above that in order to fill the positions they've got. And so this is having an upward effect, an upward pressure, especially on wages at the lower end of the bridge, and is going to cause compression, which is something that Dave's going to be talking about in more detail shortly. The other factor that I think that I've really felt is that there are a lot of employees out there that worked through the pandemic, and they worked really hard. It was a difficult time for many. Many went above and beyond, and to help their employers and the businesses they work for get through those challenging times. And so now they feel it's time to settle accounts and to be recognized for some of that effort. And so I think a lot of this has resulted in there being this frustration and this anger that's out there amongst employees. And it's not necessarily an anger about their employers, but it's about the pressures on their finances, the difficulties that they're having to face in the day-to-day lives, let alone with everything else that's going on in the world these days. And then when you get into bargaining, those anger are being vented at the employers. And so while it's a natural reaction and something you can understand with these forces, it's a very difficult one to manage. And it is in some cases leading to some quite erratic behavior. So that's on the union and the employee side of things. When we're talking about what's creating a challenging environment, we also have to look at the employer side of the fence. And, it's not cheap for employers to operate businesses either. Their inputs and their costs are in almost all cases going up, and not by little, by quite significant amounts. And so in an environment where their costs are going up in all areas, labor costs are an issue that are of heightened concern. And well, I think most employers recognize the need to provide their workers with fair and reasonable increases. We're seeing increasingly so there being large gaps between the expectations on the union side and what employers are reasonably able to deliver. And so that's resulted in an increase in work stoppages. And we've seen that over the last 6 months. And I think it's safe to say that that's a trend that is going to continue, if not intensify, as we move into 2024. So just a little bit more about wages before I turn it over to Dave. And on wages, some of the stats are quite striking. So I sort of saw an inflection point on this about Thanksgiving, and since we're at American Thanksgiving, Canadian Thanksgiving of 2022. So late summer 2022, there were still deals out there that were sort of closer to what we were used to in the old days. But as we started to move through the fall of last year, we started to see things change, and then that change has sort of accelerated over the course of 2023. And so by the middle of 2023, we're seeing average wage adjustments in first-year contracts of up to 7.1%. Right? That's huge. Now, I want you to read these stats with caution because they don't tell the whole story. It's not to suggest that everyone's getting a 7.1% increase to general wage rates in year one of contracts. There are some people that have been giving that and more, but that doesn't, but the costs are going up, and they're going up at a level that we haven't seen since the early 1990s. And so we've seen a huge pressure to front-end loaded contracts and bigger increases in year one, but the increases in the tailing years of the contract still higher than we've been used to, at least over the last 10 or 15 years. And you see that they are up in and around the 5% range. Okay. So costs are going up. Governments are trying to keep inflation down. And so it's this cycle. The wage price spiral, easy for you to say, is something that you may have seen in the news, and with some of these costs being passed on to the consumers at the end of the day. But as we all know, not the full cost of this doesn't get passed along. It's borne by employers. And so on the next slide, we just sort of see this depicted. It's very difficult to read, but as you will see, the increases we're seeing now in this spike that has happened in the last 12 months is really pronounced. It's not something the likes of which we've seen in quite a long time. And the environment we're in, this is something that we're going to have to deal with for the short to medium term, at least. So with that, having set the stage, I think I'll turn it over now to Dave, who's going to talk a little bit about some common themes we're sort of seeing across the bargaining tables across the country.
Thanks, Ian, and happy Black Friday, everyone. Some of you may be multitasking and being online looking for deals, and I think the message from what Ian just told us is employers have been finding great deals in the last 15 months or so at the bargaining table. And so I think the question is, just following up on the upward pressure on wages slide that Ian was just talking about, is has it peaked? And I agree with Ian that like there seems to be a change in what's happening within the economy. Now, in my experience, there's a lag in what happens at the bargaining table between where the economy's at and what we're seeing in union demands. And some of that is because it takes time for comparative information to be available to employers and unions in what other earlier settlements are. There's a reporting delay. But there is also sort of preparing proposals and that sort of thing. So I think we're going to continue to see really hefty demands from the union side with respect to wages and remuneration increases. And they're not necessarily going to track what's happening with inflation. But in my jurisdiction in British Columbia right now, in the third quarter of 2023, inflation's now at 3.5%. And that's down from the 7 to 8% annual increase that we saw in 2022. But the wage pressure is still there year over year. This is in all industries in British Columbia. So union and non-union, the year over year wage rate adjustments are 6% up from 2022. So this is a real thing. Employers are being hit, and in many ways that gets passed on to consumers. So we're going to now talk about a provision of many existing collective agreements, and that's the cost of living. So if we can go back to the COLA slide, so a cost of living adjustment is in addition to a negotiated wage rate adjustments. So that often collective agreements will have the annual increases set out in tables, whether it's percentages or cents per hour, but there'll be an additional provision where dependent upon inflation, there can be an additional adjustment that either goes into the wage rate or is a one-time payment. And that depends on the language in the collective agreement. In the 25 years that I've been practicing labor law, I had never had to give advice on COLA until 2022. And it caused me to panic because one of the reasons I went to law school is I'm terrible at math. And so I had to figure out what the correlation between consumer price indexes were and what was actually happening in the society, and then applying in the economy, and then applying that to the COLA language in the collective agreement. It's confusing, but the end result is, for example, we have here the BC unionized public sector employees. They're going to receive a 1.25% COLA increase in year 2 of the public sector contract in British Columbia. And that's in addition to the wage rate adjustments that were agreed to in the collective agreement. So COLA is a real thing, and unions that don't have it are starting to ask for it. And Karine, I think you are going to speak to what you're seeing at the table in Quebec.
Yeah, some union, I don't know if it's been the case in the rest of Canada, but in Quebec, and I'm thinking about the steel workers, they've been asking for years and years to do not apply COLA section, but they insisted on leaving those articles within the CBA with a special mention that it's not applicable, so they can still have it there when the time comes, and it is this year. So all our negotiation with steelworkers, it's a very huge and strong demand to have COLA back. So I don't know about you too and the rest of Canada, but it will be a very difficult thing not to consider it this year.
Yeah, I think that's true. I think in agreements that have had it, it's been a dormant provision. It's not dormant any longer, and we're going to continue to see it coming up at the table, either being adjusted for agreements that have it or being introduced for agreements that don't. So Ian also spoke to some of the underlying factors in the difficulties for employers in achieving agreements. And this is what's in our next slide, which is some erratic behavior, or not erratic necessarily, but it's just behavior that we haven't seen from the people across the table. And this focuses more on the union's role as a political entity, and what's happening in the economy and employee expectations. I think a lot of trade unions are having difficulty managing expectations of their members. And that's leading to very high demands, unsustainable demands, unrealistic demands sometimes, but they're being maintained right to the very end and into labor disputes. Ian spoke to the very real pressure that all employees in Canada feel with respect to wages, or with respect to cost of living. So after the years of low inflation and low wage increases, many trade unions are taking the position, now is our time. Now is the time to get paid. And employees, that message resonates with employees. So this is something that we're seeing come to the table. And once sort of that feeling has been let out, it's very difficult to rein it in. And I think unions are struggling with that. And so what that leads to is difficulty containing demands to reasonable levels, difficulty agreeing to tentative agreements, and difficulty ratifying collective agreements. So all of this is fueling in some ways the higher strike activity that we're seeing. And it's a mutual problem for employers and the trade unions. So moving on to another thing that Ian mentioned briefly, and we're going to look at this because we're seeing this in many sectors, wage compression. So wage compression is simply where the gap between the entry-level wages at the bottom of the wage grid and the top-level wages is shrinking. And we're seeing that, and it's been intensified in the past couple years. And it's driven by a number of factors, but it's a difficult bargaining environment where employers have, in wage grids, in longstanding collective agreements, you have either a situation where you can't hire people at the starting wage rate, or the starting wage rate, as reflected in the collective agreement, is eclipsed by the minimum wage adjustments that happen provincially. Up against that, you have your top wage rate, which for many, especially private sector employers, will be sort of what is determined to be what the market can afford, like what the market rate for that top wage rate position is, whether it's across an organization or when you're looking at your other competitors. And when that gap closes between the top rate and the bottom rate, you have a problem in how you're going to create your wage schedule in a way that employees will accept it, but also how you can set your organization up to recruit good new employees and retain your existing employees within the collective agreement structure. So I want to be clear that when we're talking about wage compression, we're not talking about pay equity. That's an entirely different a concept. And we recommend you attend Fasken's other excellent seminars on pay equity. But from a collective bargaining perspective, wage compression is something that you're going to have to look at. So if we can move to the next slide, please. So there are underlying issues driving this phenomenon of wage compression. It's the minimum wage increases that we talked about. Last year in my province, in British Columbia, the minimum wage adjustment was 7%. That's a significant adjustment for many employers. The experience that employees had with employees and other members of the public had during COVID with government handouts. And that has driven, in some ways, economic expectations for some employees, particularly at the lower level, and a hot job market. Now, I think that along with inflation peaking, the hot job market may also be turning a corner. But when you have more vacancies than you have applicants, that tends to drive up the bottom end of your wage scale. Some unions find wage compression as desirable because it decreases large wage disparities. But I've been at the table where unions, particularly in the retail sector, will say things like the government is taking away their organizing ability when you have significant minimum wage rate adjustments that put collective agreements underwater, or the bottom part of the scales underwater, the unions can't go to non-union employees and say, here's the union advantage, at least with respect to wages. So it's not something that's uniformly seen as a good thing on the union side. So I think we'll turn the next topic over to, which is employee well-being, to Karine.
Yes. So with COVID and all the working from home and new problems, we see new demands with regard to putting into the CBA some well-being sections. And we surveyed in our clients, and some survey have been going around with HR leaders saying that it is top priority as well for the HR and as well for the union to have some mention of well-being within the negotiation and the CBA. So what we see some ask for greater flexibility in working arrangement, could be better insurance, better working from home conditions. They want some more better, greater benefits. And we know that there's some cost to those benefits. And we see ask for personal days, sick days. The living wage is very popular in Quebec right now, as you might have heard on the news. A lot of unions are asking for a job recognition about having a living wage, something that will give us the ability to do the groceries and have some food on the table. So they really use the card that what we pay does not provide enough for people to eat. And it's really the messages and the speeches we have at the table. So all those arguments leads to some ask that we add on the objective or the introduction of the CBA, that the employer will make all the effort to provide well-being to employee. And this, you can see it on the next slide. We add into the slide an example of one of the CBA to promote the morale and well-being of all employees and the bargaining unit of the union. So we see that this is a very important for them. So this is one of the new trend we wanted to talk about. I don't know if Ian or Dave have specific comments on those trend with regard to well-being.
I think just to say that when we're talking about wages and the more financial key financial items, there's a lot of other stuff that's out there as well. It's not just money. It's the holistic package that people are looking for in order to make themselves whole and to address the deficits that have been exposed by the pandemic and by everything else that people are going through these days, whether it be expansion of benefits for mental health counseling or for physically demanding job, expanded or creating massage and physiotherapy benefits. These are all demands that are being made different at every table. They're important, but they're also not inexpensive. And so when we're talking about this holistic package, it's about layering, and it's important to try and address as many of these items as you can. But when you're already being stretched on some of the other financial items, being creative in these areas is very, very important.
Yeah, and I agree with Ian. And I think one experience for all employers, whether it's unionized or not, is the growth of mental health considerations and employees being much more open about talking about mental health issues in the workplace, and that's a good thing. And we're starting to see that at the table in with some bargaining demands, whether it's time away from work to deal with mental health issues, whether it's greater support in work or at work to deal with mental health concerns of employees. And there are financial implications, sure, but organizations also have to think about what do we have available to us and in order to respond to some of the demands you're seeing at the table, and to be able to speak intelligently and respond to the requests coming from the trade unions or your employees about how people can stay healthy in the workplace. And that's not just physically healthy, it's mentally healthy.
One final point on that would be demographics. Depending on the workplace you are in, demographics are changing. In some cases, it's because workforces are getting significantly older, but in many others, we're seeing a generational shift where older workers have started to retire and younger ones are coming in to take their place. And the asks that I'm seeing in respect of, depending on where you're at, very different. And so that's something else that is important to note. It's not just what your current, changes based on the changing demographics of your workforce.
So other notable trends on the next slide. We obviously cannot insist enough on the very huge wage increases we see. And I can also tell that I feel, and I think it's kind of a common feeling about the longer of the negotiation. 5-10 years ago, negotiation after 4-5 negotiation session, we were ready to talk about the monetary items, and it was mostly after few other session it was over. Now it's months and months of negotiation, and union feel very powerful, and they will drag the negotiation much longer. And before, its deals are often much after the expiration of the CBA. We see a very huge part of retroactivity that's been asked, and it becomes so heavy on the employer that we try to kind of switch it to a lump sum or signing bonus. And we saw a trend, union refusing those signing bonuses and insisting on getting the full retroactivity. And this drags again to conflicts and strikes. And I have the feeling, and I survey my colleagues here in Montreal, that we feel that the union kind of want to go on strike, and there's a pressure and anger to go no matter what we offer. It's a lot of frustration on our side, but the necessity of the strike and the pressure the union have from their assembly is quite heavy. So this is the few lines. I don't know if my colleagues want to add on the notable trends. We will touch base them later on the presentation with some cases. Otherwise, I'll leave it to, I think, Dave for the next section.
Sure. Thank you. So we're going to talk about some of the some governmental policy issues that are coming to tables, and you may see come to your table in the near future when you're looking to renew your collective agreement. And the first one we'll talk about is the disconnecting from work. So federally, the federal government in 2020 formed a right to disconnect advisory committee. And this is a concept that started in Europe, particularly France. But in France, there is legislation that says that employers who have 50 or more employees have to have a policy that addresses the use of smartphones. So your emails and that sort of thing. And just anecdotally, my sister works in France, and I was visiting her in the fall, and she would put her phone down at 3 p.m. and say, I don't have to speak to anyone. And I'd be sitting at dinner answering emails, and I was quite jealous. But from an employer perspective, it is difficult. And so we see the various stakeholders in these committees talking about this issue, and some very different perspectives can be shared. So the committee heard from a number of parties, including the representatives of France and Germany and the International Labor Organization. They also heard from employers in federally regulated sectors, as well as trade unions. And in February 2022, the final report of the Right to Disconnect Advisory Committee was published. And there was a divergence in how government should proceed. And this went down, not surprisingly, on the labor relations divide between employee representatives and employer representatives. And that included whether there should be any legislation at all on this issue. But the committee did provide some recommendations, and we set them out in the next slide. And that is that employees should be paid for all work performed, that positive work-life balance is a key goal for both employers and workers, and there's a need for flexibility for both workers and employers. And what the federal government has said is that it is going to follow up this, and it plans to bring forward a right to disconnect policy. And so we don't know what that looks like. We don't know what policy means, whether that means legislation for federally regulated employers or whether it's just guidelines. The province of Ontario, in the next slide, also brought this forward in 2021, or similar concepts, where employers with 25 or more employees need to have a written policy about employees disconnecting from work. And so I don't know, Ian, if you've had any experience with this, or you want to chime in at this point.
Yeah, it's a tricky issue, and it's one that is getting raised by office workers on a quite regular basis, and I often see it tied to remote work and the two issues. And those are things we would never had to bargain before. But people are not only expecting to be paid what they think they should be paid, but they're also looking to put protections and boundaries to make sure that work-life balance concerns are addressed. And so the policy requirements in Ontario, in terms of the legislative scheme, are actually very process-based. You write a policy. There's no requirements about what has to be in the policy. You just have to have a policy and publish it. But what it's doing, I think, is sparking a conversation and is resulting in things like unions bringing these issues to bargaining tables. And I think what we're likely to see is the unions pushing for enhancements that will then trickle down to the economy at large.
Right. So I think when you're developing, and this is for Ontario-based employers, but other jurisdictions will see these things happen, or federally as well. So if you're developing these policies, you have to consider what's happening about an employee's requirement to respond to communications after regular working hours. How you can put on a out of office notification and what that means for people as with respect to timing and expectation of replies. And just understand that at least in Ontario, that if you provide a benefit under your policy that's greater than any employment standard with respect to hours of work or that sort of thing, that is something that's enforceable. And that's true in British Columbia for employment standards as well. If you have policies that exceed ESA in some areas, BC doesn't have a right to disconnect language, but the Employment Standards Branch may look into that. For unionized employers, where we could see this issue arising is questions about hours of work language and collective agreements, pay for work done remotely, outside of the regular hours of work. And so just be alive to these things, and also have a look, if you have a policy, how that could implicate and be swept into your collective agreement. Unions have picked up on this issue, and we're starting to see this. In the next slide, we have an example from Unifor. I believe this is from 2022, but when Unifor had its policy summit on how to address the next 24 months of collective bargaining, they have put in issues around disconnecting from work. And certainly during the federal labor dispute, last summer, which involved CRA employees, the right to remote work was the main, as I understand it, was essentially the main bargaining concern that the union was bringing forward. They wanted to have rules on how frequently they were going to be in the office. That's a slightly different issue than being disconnected from work, but there are overlaps in how that happens. Looking at the next slide, the Unifor statement says that one of its key bargaining priorities is negotiating a right to disconnect provision that limit workplace communications outside of work hours, allows members to refuse answering work-related emails, messages, or calls, and that there be no reprisal for that refusal. Unifor talks about key trade union principles for ensuring workers' rights when working remotely, including a restriction on how employers can surveil remote employees. Remote work should be voluntary. Work outside of regular working hours should be voluntary, and employees have a right to disconnect. And that employees remain responsible for health and safety of workers wherever they are doing their work, and that work equipment and costs be borne by employers. We've also seen some language, and as Ian said, you can download this material, the slideshow. And so the sample language, I won't go through in any great detail, but we have a statement of some of the union sample language in our next slide. And we'll let you review that. So it talks about, so this is sample language, which the union policy summit basically said, this is the sort of thing you should be looking to put into collective agreements. And so we have 2 slides of that, which we'll let you review. And then coming back to the government issues with labor implications, this disconnect from work. So the federal government's final report, the primary recommendations by unions included that the government adopt a robust legislative requirement for workplaces to establish a right to disconnect policy, and that a voluntary approach will not work. And the union movement is recommending a statutory right to disconnect with a legislative definition of what is deemed work. So that the goal of the union movement in proposing this sort of statutory approach is to reduce the ambiguity of what it means to be at work. And the unions are pushing the federal government to say that it needs to consider the impacts that 24/7 on-call work expectation it has for employees. Of course, the economic interests of employers need to be kept in mind, but the union movement says many workers are struggling to keep up with demands of the workplace, and workers deserve to be paid for the work that they do. What we see from the employer community is set out in the next slide. And the employer community that participated in this process recommended that a legislative or regulatory requirement should not be adopted. They said that the parties should be encouraged to develop policies that ensure a proper work-life balance for employees. But beyond that, the employer community said, look, any further sort of governmental interference will limit our flexibility in responding to issues in the workplace. And employers recommended that any consideration of a right to disconnect policy should take into account the need for employer flexibility to not hamper the employer's ability to conduct business, particularly when they work in multiple jurisdictions where the same rules don't apply. So you can't. It's difficult for an employer who has operations in federally, potentially provincially regulated operations, and different rules apply to different workplaces. So the employer position was that is that every workplace is different, and a one-size-fits-all approach doesn't work, and the workplaces should be able to maintain flexibility and take into account local conditions, and to respect the principle of free collective bargaining. So to allow parties that are unionized to determine this issue themselves and not have the government address it. And the employers further said that this concept of what work is, what's deemed work, that's something which is a separate issue from the right to disconnect from work, and should be subject to its own consultative process. So that's certainly something you're going to see come to your table if you haven't seen it already. I think we have some case studies that we're going to review now on some recent labor disputes. So I'll turn it back to Ian.
Thanks, Dave. So we're going to go through a few things that are in the news, both for the purpose of just sort of a little bit of context on each one of these, and also just sort of reinforcing how it's indicative of what we're seeing more broadly and some of what we've already discussed so far today. So a big strike at the Port of Vancouver had a massive effect on the Canadian economy. If you were trying to get an appliance or pretty much anything over the summer, good luck. The delays in the supply chain that were created by the 13-day strike back in July had long-lasting effects well into the fall, a huge impact on many different sectors. And so this is all a result of a situation where about 7,500 dock workers in and around the Port of Vancouver went out on strike. This is a situation where it's a group of employers negotiating with one union, and in addition to all the monetary and other sort of more standard issues that you raised, there were a couple of other issues here, most notably a significant dispute about contracting out of maintenance work on new equipment that was being brought in. And so what's interesting here, I think, is the way the federal government reacted. And I think it's indicative of what we're seeing governments do all across the country. There was a time when there was this significant disruption to an essential artery of the Canadian economy, the government would have stepped in without too much delay and sort of ordered people back to work and created a dispute resolution system that would have allowed the economy to sort of not get off track, and then allow the parties to resolve their disputes through interest arbitration or some other mechanism. But that didn't happen here. The government is now firmly entrenched in the position that it's not going to intervene in disputes of this kind, that while it'll try and exert and do some twisting of arms behind the scenes, they're very reluctant to introduce back to work legislation. They feel that the better approach is just let collective bargaining play itself out. And so that's something I think we're going to see more and more. And so, I think the strike at the Port of Vancouver was just the start. And over the next 12 to 18 months, pick a sector, there's going to be strikes that are very disruptive to the Canadian economy, and there's the potential that they won't be short ones. In this case, the government sort of did get very frustrated after a time, got very actively involved in arm twisting behind the scenes, and then eventually got the Canada Industrial Relations Board involved to try and mediate a settlement. Now, the problem here was manyfold. They thought they had a deal, and then the union couldn't get agreement within the union side before they even took it back to their members. It was a disaster. The board got really furious with everybody involved and was threatening if they did that again, there'd be an unfair labor practice complaint. And at the end of the day, they were able to broker a deal. But the effect it had on so many people, and so many people outside of just those that work at the dock, was noteworthy. So 4-year deal, 5% in year 1, 5% in year 2, 4% in each of years 2 and 3. But really, this is, we put this on here more to talk about sort of the impact and sort of the trends in sort of government action. Dave, I know you're right there next to the port almost. Is there anything you want to add in terms of additional context?
Yeah, no, this was a massive dispute, and the impact to the economy. It's hard to imagine a more impactful private sector dispute in the country. And what was really interesting was the unions were going to go out no matter what was on the table from the employer. There was going to be a strike, and that political infighting that Ian described was real. There were agreements, tentative agreements agreed to by the union side that it couldn't pass within its own union hall, let alone put to a ratification vote. And then the ratification vote failed. So that's a really interesting snapshot into a loss of control and the individual membership being out of line with the union leadership. And that's happening, I think, in most trade unions. They have a very difficult time controlling members. The other really notable thing about this dispute was the union. I think the bigger issue was they were fighting against contracting out of maintenance, but they were also fighting against automation, and it was aimed in many ways, not just at wage rate adjustments, but it was protecting their jurisdiction. And, those of you who've bargained these things and had unions come and said, we want to restrict the employer's right to automate, the answer was, that's a management right. Like, we're not bargaining that. And that was a foundational piece of the union's approach. And they, in some ways, were successful in putting in this restriction. So it was a difficult strike and an interesting summer here.
So moving industries now, auto sector. Notable settlement from Ford. So sectoral, I was going to say sectoral bargaining. It's not, but they, the union, Unifor picks one of the 3 auto companies, negotiates with them first. They set a pattern, then they apply that pattern to the others. Unifor picked Ford this time. Ford entered into a settlement on September the 19th. And so the numbers we were talking about earlier were sort of up to the summer. So this is what we're seeing in the fall. 10% increase in year 1, 5%. Sorry, just let me make sure I get these numbers right. 10% increase in year 1, and then 2% in year 2, and 3% in year 3. So 15% overall. But that's the base wage rate. There was a whole bunch of other increases in addition to that. And that's before we even get to the $10,000 signing bonus. That's not a typo. That's a $10,000 per employee signing bonus. So then we start talking about the extras in addition to just the base rate increases. We're getting additional skilled trades increases. They're condensing the period before you move up from one pay scale to the other, from 8 years down to 4. And so like the increases are massive. So to give you a sense, the average production worker saw their hourly rate go up by about $11 on average. Okay. The top production rate at the end of the 3-year deal for a production assembly employee is going to be $44.52. And the skilled trades, $56. right? So, this, and that wasn't it. There's a whole bunch of stuff in addition to the wages and these sort of, so on the benefit plans, they agreed to a DB pension plan for certain employees that only had DC pensions beforehand. So that's a major concession. They got concessions sort of in the 2012, 2016 time period. And they gave all those back and then some. Not only did they agree not to close the facilities, but they also agreed. So, for example, in Oakville, which is one of the main Ford facilities here in Ontario, they're moving to EV production, electronic vehicle production. So they got a massive amount of money from the government. And so that's kind of what's underlying a lot of this. There's been a massive inflow of public funds. They're going to have to transition and build all these cars. And so now some of that is flowing through to these collective agreements. But they're going to have to shut down the Oakville plant for a significant period of time, starting in about middle of next summer, 6-8 months or longer to do a transition. And so they agreed all sorts of quite generous pay protection increases for the employees that will be impacted by that. So, noteworthy in a number of respects, but the signing bonuses are key. So in terms of a couple of trends, you see this front end loading of the wage rate increases. And then you can sort of see that signing bonuses are being used to sort of offset what the unions may have otherwise been asking for in percentage additions to further wage increases to the base wage rate. So this is the largest increase to a general wage rate in Unifor's history. And then as we go to the next slide, you'll see that there was a similar settlement with General Motors entered into later in the fall. Now, some of the details are a little bit different, and if we could go to the next slide, please. So this was a settlement that was entered into in October, 4,300 workers. Again, there had been some separation of wage grids over time so that more junior employees were subject to slightly different pay rules than people that had been there for longer service. Those are being, if not eliminated, then the period which you're subject to this pay restrictions dramatically reduced. And employees, so what we're seeing here is them trying to make up for the concessions that were given over the last 15 years, and especially with the auto crisis sort of in 2009 to the 12 period. And so, junior employees are going to see a 73% increase over the life of the agreement. So, again, huge increases, and it's not just to wage rates, it's to benefit plans as well. Moving on to a different sort of sector. Another strike that sort of was in the news over the summer was at the Metro chain of grocery stores. End of July, they went on strike, 3,700 workers at 27 different stores. And so now this is a situation where going down to the deadline, they did get a deal prior to the strike deadline. That deal was recommended by the committee, who went back. The hope was that it would be ratified, and it wasn't even close. And so, they ended up going out on strike. The strike lasted a month. They did end up with a 5-year deal. And they did end up, and we put it out in the bullet points here, with some very notable increases. So this is a workforce where there tends to be some folks at the lower end, sort of at the wage scale, sort of closer to minimum wage, and in the low 20s. There's full-time employees and there's part-time employees. We're seeing huge increases to both. And sort of, I direct you mostly to the end bullet points, and you can look at some of these details, but it's resulting in very significant pay increases, okay, for employees working in this very important sector. And so this is sort of coming on, grocery workers were feted for sticking it through during the pandemic, and the momentum that was built through that, leading to what Unifor is calling a historic deal that it hopes will set the precedent for grocery negotiations going forward. Now, there's a lot more that was going on behind the scenes, and I don't know firsthand, but I've heard a lot of rumors about how the deal that was eventually accepted at the end of August compared with what was on the table at the end of July. But Dave, maybe I'll let you talk a little bit more about that.
Thanks. Yeah, I think what's notable about this particular dispute is the scale, the number of stores affected. And as I understand it, it was also accompanied by illegal picketing at the stores or at Metro's distribution centers, so which were subject to a separate collective agreement, and that I believe there were injunctions issued. Ian can correct me if I'm wrong, but that employers obviously look to restrict secondary picketing, but that had an impact on Metro directly. Within the union side, what was notable is how after the failed ratification vote, in the past, you might have seen union leadership at the national level for a strike of this size try to impose itself on the local and get involved and say, look, you had a deal. It was a reasonable deal. Let's try to settle this. That doesn't happen anymore. And in fact, what the national leadership said, our members have spoken. That tentative deal, while it was recommended, wasn't good enough for them, and we support them. And that sort of just loss of control from the national, and maybe that's the political reality, is they didn't have a choice. But that is a different world than it was even 5 years ago, where you would see national unions get involved on a strike of this scope and try to rein in expectations, try to draw things down, and not just say, we're with you, we will fight. And I think that goes back to some of the things Ian was speaking to at the start. They now have members who are angry, members who are willing to fight, and the union leaderships sees that and allows it to continue. So this I think is a notable private sector dispute that where we see employees rejecting a deal and then achieving some improvements through having a longer strike.
One other point that I would raise, and this isn't necessarily connected to this dispute, is we've also seen in recent years huge turnover in sort of the head leaders at many of the national unions. And so a generational shift, if you will, but there was strong characters at the top of many of the union food chains for many years who ruled by fiat, and one or two quick phone calls would be enough to get them or one of their key lieutenants involved, and things started to move forward at a much brisker pace from that point forward, and that was often a useful tool. We're not seeing that as much anymore. Internal infighting within unions is a real thing, and people seem more content to just let it play out in its normal course, as opposed to putting themselves on the line or intervening in ways that they might have not too long ago. But having rudely interjected myself, I'm going to let Karine sort of talk to us a little bit about what she's going on in certain things in the province of Quebec, where I'm not sure there's anybody that's not on strike at the moment.
Yeah, it's either being on strike or having a mandate to strike for the next couple of weeks. So I'll start with the Quebec school bus transportation situation. So to give you a little bit of context, if you're not aware of that, while the school boards are obviously public in the province, the school bus transportation are from the private sectors. So historically speaking, the wages for the bus driver were not that high because the contract and the offer from the school boards were so low. So any company could not offer that many good wages because of their contract with the school board. So in 2022, all the school bus drivers and unions, along with the transportation companies, all together came to the government and request better financing in order to be able to be profitable first and give back to the drivers. And meanwhile, unions were asking for a recognition of the responsibility of those drivers driving our kids to school. So while doing that, the transportations company, they ask unions, well, what are you looking for as a decent living wages? What is recognition for you so we can turn around and make sure what we get from the government will be able to be reasonable, and we won't get those conflicts, and you guys will be so happy. So union mentioned, like, we think that all drivers should have about $25 per hour as being a living wage and a recognition of of that job and responsibility. So company went to the government, got some new financing, and then all the companies went back to the negotiation tables, and it went well for a few companies, but not so well for a lot of them. When we had more than a dozen of strikes everywhere in Quebec, where union decided, or employees or members decided that they wanted more. It was more like $30 or 40 hours a week guarantee, $30 per hour. And the company didn't get that financing, so could not obviously offer that. So it becomes like very difficult negotiation with a lot of strikes, unreasonable demands, and kind of being on union on position that they were not even bargaining with, like, we want this and we won't move. So there was an article in the La Presse this morning that I really like, the example of the cat being on top of a tree, and the cat obviously doesn't want to go down. And the journalist or the person was saying that this is when the assembly, they just cranked their members, and the union are pushing to mobilize the employee and the members so much that they are like high top of the tree like a cat, and they just don't want to go down after, even though we negotiate and try to reason and show numbers and explanation, and they will just keep to their first demand and don't even go down. So it's been very difficult case for all the school bus transportation companies in Quebec, and with some media misinformation. So a lot of drama around that situation. And if we go to the next slide, there's also the nurses, the teachers, the civil servants. There are about more than 400,000 employees on strike as of today. It's a big common front of most of the unions coming together to go on strike at the same time. So a lot of services, and as you might know, like teachers and schools are not essential services in Quebec. Therefore, teachers go on strike, no school, no nothing. It could last months or weeks unless the government intervene. As of now, there's no indication that they will, but they might if it lasts too long. A conciliator has been appointed by the government, so we'll see if we will be able to have some resolution. But this is the very big actual situation here. On the next, so some of the concern that most of the employer has in Quebec, then we have been most of them already addressed, is the very difficulty to control their assembly and members. Infinite list of demands. I started a table this week, and the union has 150 demands, and it was all mixed up and difficult to follow. And they say even, well, we didn't want to say no to the member, so we put them all there. And we're like, why? Well, it's our fair representation duty. We don't want to be the one that say no to them. You will be the one saying no to them. So I was quite surprised about this argument, but now I feel more comfortable saying no, as they kind of tell me, just tell us no, and we will say that the employer cannot afford all those demands. So this is also in Quebec historically high wage increases that we've seen in all different sectors, and I've noticed longer strikes and a lot of requests to go to conciliation. The Ministry of Labor conciliation service is very, very busy with a lot of demand, and it's been a lot of headaches to employers in Quebec at least the last 2 years with all the inflation and cost of living issues. Back to Ian, I think.
Okay. Well, thank you. We're going to try and leave time for questions at the end. So a quick note on the public sector with a specific reference to Ontario. In Ontario, as many of you may know, the government introduced legislation in 2019 which actually put caps on public sector wages. Subject to certain exceptions, there was pay increases were limited to 1% per year for certain employees over certain 3-year moderation periods. And so obviously this was something that was not well received by unions and in some cases by the public at large. So litigation was commenced almost immediately, but while that litigation was working its way through the courts, collective agreements were entered into. What happened in practice is almost all of these contracts, while they had to accept the 1% because that's what the legislation said, they contained what we refer to in the slides as the reopener provision, which basically says when this gets struck down by the courts, we have to go back and renegotiate. And sort of that's where we're at, because to no one's surprise, because it wasn't difficult to predict, when the litigation finally made its way through the courts, as we can go to the next slide, we got a decision in earlier this year, and I guess what I would say is that the challenge here was that the effect to intervene and collectively bargain and prevent people from freely collective bargaining was a breach of the Charter, and specifically Section 2D, which deals with the freedom of association. And so the government said we're entitled to do this. We've got fiscal restraint obligations. We're trying to be responsible with public funds, but the courts didn't buy it. And the rationale is set out on the next slide, sort of sets out all the reasons why the court found that the government's intervention was not appropriate and why it was struck down. And so all those reasons are set out on the bottom half of the screen, and setting out all the various ways in which it was found to be inappropriate. And so it's important to recognize when we're looking at this, and I think this influences many other aspects of collective bargaining, as the result of some decisions issued by the Supreme Court of Canada, the right to collective bargaining has been escalated to a charter right, that people have the right to be able to collective bargain, and you can't take it away from them absent having a very good justification for doing so. And so this is the reason why many governments are much more reluctant now, even if politically they wanted to do so. They're more reluctant now to intervene with back to work legislation, because it would now require you to go in and be intervening in the constitutionally protected right to collectively bargain through the freedom of association. And so the courts here found that this was an improper interference with that right. It didn't balance the interests appropriately enough, and so it was struck down. So what does this all mean? Well, it means that we've got a lot of public sector workers who are, many of which are in the process of negotiating new collective agreements as we speak. So they're doing that at the same time as they're trying to get retro pay. If we can go to the next slide. So, and just in terms of, before I get into that, the case, the government appealed the decision right away. The appeal was actually heard this past June. The Ontario Court of Appeal is going to issue a decision. Depending on what it is, there's a possibility it would then need to go to the Supreme Court. But we're hoping to be getting a decision in the relatively near future that'll provide some further clarity on this situation. I think if you were to be a betting person, you wouldn't bet that the reviewing court is going to come to a different conclusion. But Who knows? Who knows? In terms of the next slide, what it's meaning here is we're in a world right now where, while the government's still trying to hold every back pending the outcome of the appeal, there's a lot of those out there that aren't waiting. And we've already seen settlements, if we go forward one more slide, retroactive settlements where an additional $1 billion in retroactive payments have had to be made pursuant to these reopener clause that I've mentioned earlier. And this is certainly doing nothing to sort of help with the inflationary pressures and all the other concerns that were raised earlier. And the estimate from the Ontario Financial Accountability Officer is the 700,000 additional provincial workers, or public sector workers, I should say, that were governed by this legislation. The retro pay for them could be up in the 8.4 billion range. So it's difficult enough to get a collective agreement, in the current climate. But then when you add the fact that in the public sector, you're also needing to deal with retro, it's a concern. So a settlement that was reached in the last few days were the 80,000 members of the public elementary teachers in Ontario. And they reached a new collective agreement, or that's what it's pitched to in the news. But what really happened is they settled some terms and they've referred many others to interest arbitration. And so in terms of retroactivity, from what the public records say right now, it's all very fresh, and so we don't have all the details yet, but it appears that they agreed to retroactive increases of 0.75% for each of 2019 and 2020. Or I may have that wrong, for the first 2 years of their moderation period. So they'd got 1% already. They got an extra 0.75 for those years. But the final year where they were subject to the cap, they're going to refer the question of what the appropriate retro increase is for that period to an interest arbitrator, with a minimum of 1.5% on the low end and 3.25 on the high end. So the arbitrator has to fix somewhere in between that for the retroactive increase. And then they've agreed to a new contract, but they haven't been able to agree to what the wage increases should be to that contract. So they've put the wage increases for each year of the contract to interest arbitration as well. So why would somebody do such a thing, you ask? Well, it could be it could be a whole bunch of different reasons. A skeptic might think that the government knew it wasn't going to be able to agree to a number that it would be comfortable having said it agreed to, and so they went to interest arbitration to have somebody else do it for them. Or there's a backroom deal, and we'll see the outcome at the end of the process. But all this is to suggest is that I suspect the numbers in those increases are going to be significantly higher than anything we've seen in recent memory. So a couple additional notes about public sector. The public sector increases are at a very different level than the private sector increases. And there are many reasons for that, but you still tend to be seeing public sector settlements, at least in Ontario, in the 3%, 3.5% range, and even lower in some future years, depending on what else is on the table. So I think there is a noticeable difference between the public and private sector, and that's in recognition of the fact that the public sector employees have a host of additional compensation and benefits outside of base wages that many of those in the private sector do not. Before we sort of move on to the last section, I'll just ask my co-panelists if anybody has any comments on that or wanted to add anything before we move on. Just a reminder that if anybody does have questions that they'd like us to address, the Q&A tab is still open at the bottom. Please type in your questions and we can try and deal with them. So maybe now it's time to move on to sort of not talking necessarily about the collective bargaining process, but maybe a little bit about managing the risk posed when you get to the point that there is or could be a work stoppage.
So if you start to distill down what we've been talking about for the last 75 minutes, it's a challenging environment for employers, and we see that unions and their members are more willing than ever to go out on labor disputes. So employers need to be prepared for work stoppages and ways to avoid work stoppages, and to keep in mind some of the trends that we've been talking about when you're planning your contingency planning for a labor dispute. So part of that includes the timing of a resolution. I think you should plan for and not expect early resolution of deals. Karine mentioned that we're seeing bargaining take longer. We're seeing many deals go on beyond their the contract end date and the contracts of the contract continuation clause. So that usually doesn't matter, but for some businesses that does matter. So the timing of resolution needs to be kept in mind. And we're also seeing often the most historically generous contracts that employers are offering will still be rejected. And that's a new development, and that's a worrisome. And as Ian mentioned, we're not going to get, if you're in a sector where the government has historically interjected with back to work legislation, that is less likely than it has been in the past. And we are having longer disputes and certainly more disputes. So you as an employer need to be prepared. That's business planning. That's understanding who's available to work. If you're going to operate during a dispute, that's understanding where picketing is going to be. But from a bargaining perspective, it's also planning out your monetary moves, the final moves of negotiations, and keeping in mind that your final deal may not be the one that gets accepted if it's voted down by ratification. Looking at the next slide, I think we kind of repeat some of these practical tips from these, from the messages that we've given you today. Unions have little control over members. We're seeing that. That might affect how you communicate during bargaining. You might want to put out your proposals. You might want to put out your rationale more public, have them publicly available for your employees to see. Don't rely on the old union silo of silence. That may not work for your workplace, but it's something to think about. Be prepared for your monetary offers to be turned down, and maybe even by offer, we mean something that's been accepted too. Be prepared for that. Employers can't be too reactive in this environment because labor disputes are less of a threat, I think, for many employees right now. And the general feeling right now, and this could change if the economy goes down quickly, the general feeling from employees is it's their time to get paid and they're prepared to fight for it. And Ian mentioned interest arbitration and what that means. So this is binding arbitration where potentially you avoid the possibility of a ratification vote. So binding or interest arbitration is something that you need to have planned out whether you're going to be interested in that in advance. You need to sort of work behind the scenes with the union to see if that's something that they're interested in. Some sectors and operations have interest arbitration automatically written into them. How you refer the matter to the arbitrator and what you tell him or her that you're asking them to resolve is important. So think about that. Get advice on how you're structuring the deal to go to the interest arbitrator, because you're going to be stuck with the results. So make sure that the arbitrators know what you're asking them to settle. Ian.
Yeah, just a couple of additional points. There have been several tables I've been at recently where we're actually planning and expecting the first recommended settlement to fail because that's just what's going to happen, no matter what we put on the table, no matter what it is. So it's a very different way of negotiating. It's almost like negotiating in phases where you have to be aware, we have to put something out there that's reasonable, that we can stand behind, that makes sense given the priorities that we've communicated across the table. But we also have to leave ourselves enough room. That when and if the likely event it gets turned down, that we've got something left, so we don't end up spiraling into a lengthier dispute than is necessary because we hadn't planned properly. So this is a new way of thinking. Like, I'd spent many years trying to train bargaining units to take a recommended deal because it's not going to get any better if you turn this down, and that's how we got people to accept things. But the new generation and the way things are right now, it just doesn't matter. Poor reps who have to go sell these things just getting chanted and yelled down before they've even opened their mouth, before they've even told them what they're voting on. I've heard some stories that are just truly, truly amazing. And the other point I would make, It's been a long time since a lot of people have been having to deal with this. We've had a lucky period where things tended to get resolved much sooner in the process. It's really stressful on everybody when you're getting down to the wire, and heaven forbid there's a stoppage or a dispute of some sort. It's very easy for things to get emotional. It's very easy for people to want to be reactive. It is too easy to take the simple thing. Well, I got to tell people what I think, and they need to know my position, and we need to take action, and we need to do this. Sometimes the best thing to do is nothing. Sometimes you just have to give time the people in the space they need to figure things out. And that by being too aggressive or actually, pushing things, you can actually make things worse as opposed to better. And it's sort of striking because a lot of the folks, especially if they're involved and they're not necessarily from the local community, won't appreciate all of the nuance and sort of the best of intentions leading to unintended results. The final thing about interest arbitration, to supplement what Dave said, if you think interest arbitration is going to be an option, you need to be thinking about it early in the process, because what you leave as open items on the table and what you want to resolve could be different depending on if you think interest arbitration is your desired outcome or a likely outcome. And you certainly don't want to be only leaving the difficult items where you've got no room to move in interest arbitration, because there's going to be a whole separate process where you'll likely need to give on some of those items as well. So a delicate balancing act. Karine,
I add a tip too. It's like, I don't know about you too, but I feel that the argument, like, I feel like I negotiate against myself, that we usually say to the union and they'll say, okay, we'll come back. And now we say we feel we negotiate against ourselves. And I think employer that really want to get a deal out of this might be ready to do it, because saying no, we won't counter offer on our own offer, is kind of a block on the other side, I feel lately. And we do negotiate against ourselves, because I say we are the adult in the room. So if we want to just get a deal out of it, we sometimes need to do it and just let our ego out of the room, because unions have big ego lately.
And then the final tip I would say for the people in this session who are at the table, who are leading collective bargaining, is also manage expectations on your own side. Make sure that the people who aren't at the table within your organization, who are going to ultimately have to approve the deal that you are recommending, know what the trends are, know what the expectations are, so that they're not surprised when you're coming and you're saying, well, they're still asking for 9%. That's not their opening offer. That's what the union still like. So you don't want to have surprises in your own C-suite where you're going and saying, like, look, here's the reality, and this is why we need to be ready for a labor dispute. So, there is contingency planning internally as well as externally. So, we do have 8 minutes left. I think Ian's going to start looking at questions, but please provide us with questions so we can answer anything you're looking for in the next 8 minutes.
So I'll throw the first question out to the group. With the potential of inflation starting to slow down, do you see that having an immediate effect on bargaining demands, or causing those demands to sort of ease up a little bit as we move into 2024?
Yeah, I don't see it affecting the demands. Certainly not in the next year, unless the economy really goes down. I think that we're going to see elevated demands for the next 18 months at least. And we're not, at least the Bank of Canada is saying, we're not going to see 2% inflation again, at least until 2025. And that's, and I think that's looking in a crystal ball too. So I think we're going to continue to see elevated demands from the union side. And I think it's important for employers to understand truly what they're able to afford, and truly to understand what the market is, so you can respond intelligently to these record demands.
And I agree with that, Dave. The one thing I'd add is that once other unions are out there getting settlements and they're published and the percentages are out there, it's very difficult for other unions, even if they're negotiating it 1 year later, to not try and go out and get the same or better increases than what their members are seeing, because they will be showing up to their union proposal meetings and to the ratification vote meetings with full knowledge of what those comparator deals are. And so there's going to be a lingering effect that I think could last even longer than 18 months, depending on how things go out. But Karine,
Yeah, 2 years ago, employers were like kind of sad or upset to go and negotiate because the increase was coming to get higher and higher. But I can tell you that those employers are happy that they did it 2 years ago, because now it's even more. And no, I don't see it easing up in the next 6 months for sure, unfortunately.
The one other thing that I'd say is an interesting phenomenon is length of contract. The days not too long ago, many employers would push for a longer deal. You might have to pay a little bit more for a fourth and fifth year, but it saved you from having to go back to the table and negotiate everything else, and was often a good bargain. And it was unions who were pushing back on that because they wanted to get back to the bargaining table as soon as they can and be able to negotiate more and more and more. But what I've seen a shift where recently employers are more reluctant to commit, in some cases, to longer term deals, because they're hoping that 3 years from now, the economic climate, inflation, all these pressures may be better, and they can negotiate a better deal then than they are right now. And so I've seen this strange dynamic where unions are saying, are we ever going to have a better time to negotiate a deal now? Let's lock it in for a longer period of time. And so I've seen pressure for them pushing for longer deals, and employers being the ones to say, whoa. Not that they're not doing it in some cases, they are, but in some cases they're being a little more reluctant because they're concerned about overpaying. So the next question is about remote work and a movement to 4 days per week, or there being specific restrictions inserted into collective agreements dealing with remote work policy issues.
Well, maybe I'll start. Speaking to a flexible work week, I've seen that more bargained recently than the remote work. It hasn't trickled down to many of my clients, but the flexible work week, the answer really depends on the workplace and what the needs of the employer are. I'm at one table right now where the union's resisting a demand from an employer to move to 4x10 schedule. Because so many of its employees are working overtime shifts with the traditional schedule. So it really depends on where they're seeing leverage and what the employer needs are with respect to flexible working. I think that many workplaces have implemented longer shift schedules for fewer days worked. And that brings with it concerns around, well, how do you give people schedules when they're working, 12-hour shifts, when they're working 7-day sets? How do you figure out the other parts of the collective agreement when you're introducing new shift schedules? Mm-hmm. Remote work, and maybe Karine, you can speak to that.
Yeah, well, before that, I was about to say that what I've seen coming more and more is the pre-retirement section. So unions and employers to retain and to retain employee, they are more flexible into getting pre-retirement schedule. So the 4 days a week or shorter shift, even in manufacturer. So this is the new trend I've seen more than the workplace or the working from home or the flexible days. It's really for the more aging employees.
Another question came in also relating to remote work and the impact it's had on contingency planning. And so what impact the increase in remote work has had on contingency planning. I had a couple thoughts on that, but I'll throw open the table to you guys first.
We are waiting for a Court of Appeal decision here in Quebec about does the notion of establishment apply to working from home employee in terms of when employees are on strike. Well, this is pending, so we'll see if employer get a win for this one.
And so I think this is pointing to a general trend more broadly, and about replacement workers. As you will, as everybody's heard lately, our federal government, in its infinite wisdom, is introducing legislation that will ban the use of replacement workers of any kind, including salaried staff, to perform bargaining unit work in the event of a work stoppage. It's a draconian change to the traditional balance that I would argue is built into our system and part of what makes it function. And so, in addition to doing that, they're making radical changes to the essential services process. So this legislation is still, it has not passed. It is still, I believe it's just passed first reading. It's in second reading, so it's still got a number of stages to go in the legislative process yet before it's finalized. So it could be several months before that happens. The legislation is designed so there's going to be a long lead time between when it gets royal assent and when it comes into effect, 18 months. That may take us past the next federal election, so who knows if it actually makes it all the way to implementation. But I mention all of this because there's a shift, whether it be remote, whether it be people in the office. Governments seem to be trending towards rules and requirements that say you're not allowed to use anybody to replace unionized workers in the event of a strike. And that includes salaried staff or managers who aren't part of the bargaining unit. And that applies whether they're on site actually doing the work, or in today's world where more and more can be done remotely. So will it stop them from, if you've got people in the marketing department or people in sales who aren't part of the bargaining unit, yeah, they can work remotely and continue to do their jobs without interference. That's probably going to be a significant help when it comes to contingency planning. But when it comes to actually doing the work that the bargaining unit's doing, I think we're seeing legislatures across the country slowly starting to tighten the noose on that, and we're going to need to find a new balance.
Yeah, I think we'll all know that we're in a brave new world when your neighbor who's been working remotely, you find her sitting out on a lawn chair with a picket sign on her front lawn. Who knows if that's going to happen or not? But the workplace is changing, and how people are striking is changing, and being able to plan around labor disputes is going to be affected by replacement worker legislation. Quebec and Ontario have it already federally; it's happening, and I think more provinces are going to get it soon. So,
well, we've come to the end of our allotted time, and so we just wanted to say thank you very much for attending today and your time and attention. If anybody has any further questions, you're more than happy. We encourage you to reach out to one or more of us, or to whoever the lawyer is you deal most regularly on the Fasken team. Just where we started, there's the survey link that you can find on your screen. We would sincerely like any feedback that you would like to offer. We hope you find these year in review sessions helpful, and we look forward to seeing you at our next event, which is only a few weeks away. Thanks again for your time, and everybody have a great weekend.